Hey, Alysa.
Hey.
Hey. So we're here at the IAB Privacy Compliance Salon. Great content,
really
right? Got into the nuance, wasn't too high level. It's not to see with these conferences. Loved it. My pen ran out of ink, actually. Yeah, I got a whole book of stuff to talk to you about.
Let's go.
But we're going to keep it to 5 things. So, firstly, your session on health data, just the complexities that companies are navigating on this, right? How you define it. I mean, just tell us a bit about what you guys found.
Yeah, so we try to really focus on the questions that we are hearing all the time, and maybe it was unfair because some of these questions don't have a clear answer. But starting with just what is health data? You know, that is easier to say in concept, a little harder, obviously, to apply in context. And so we really try to break that down, talk about particular use cases, and maybe the theme of that was ask a whole lot of questions. The use case matters, context matters. And then we talked about scalability, because if you're putting so much human time assessing, how can you do that for just at scale? And I think there were some really practical points that were relayed in, you have a playbook, you see patterns, don't let perfect be the enemy of the good, but you really just start creating your program around that. And obviously you're going to iterate. I think there were some other really good takeaways. Gating questions. Are we in HIPAA land? Are we not? There was a lot of, we called it buzzword bingo. You know, you hear privacy safe, de-identified, tokenized, hashed, anonymous, not PII, all these things. And we all maybe mean something different with what we're saying. And so maybe the first question is really probe. What do you mean by that? Yeah. So that you can at least make sure that your understanding of the facts of just the data flow is the same as the person on the other side who's trying to explain it to you, so you can do the risk assessment.
Seeing that a ton, like, so for example, no, we don't have to worry about that because the data is anonymized. What does anonymization mean to you? Are you collecting IP addresses? Yeah. Well, actually, and this broadening of the net that gets captured by this, like, we used to think of it as, all right, so those HIPAA regulated entities, and then the non-HIPAA but still healthcare, and then actually also consumer goods. And then actually publishers, like, what if someone's reading an article about mental health? Are they caught up in this, reading about vitamins? Like, how do you figure this out?
Well, so I always kind of start with follow the money. And it's been really interesting to put together. On the one hand, you've got pharma and healthcare and even retail media, I'll say lowercase h for health and wellness, because the lens just got so big. Mm-hmm. And part of it is the way that we think about how we take care of ourselves. Healthcare can be certainly go to the doctor, but it can be your fitness routine. It could be the nutrition, the meals that you're eating and how you're tracking that. It can be just wellness, dietary supplements, and the money. If you look at like revenue projections on retail media in this space, it's billions and billions and billions of dollars. And what I thought was really interesting in the panel was like the disconnect between the privacy legal side, that's business is not as usual. We're not the people of no, but we're trying to certainly do it not in a flagrantly violative way. There's a way to do it thoughtfully. And yet you have on the pure business side, let's just say, trust is really important, but when you peel that back, what does that even mean on the business side? And we're not yet speaking the same language.
I thought that was interesting too. $100 billion in retail media network revenue. We know search dollars are flowing to it like crazy. So businesses are going to chase it. And while they're chasing it, they're saying the consumer's at the center of this thing. And these are businesses that they're not media companies, they're merchandising companies. The consumer's important. Now they're going to see ads on that website, they're out of context a little bit on endemic. And are they talking to their privacy lawyers about this? It felt like maybe they weren't quite just yet, but they should be.
In a strategy.
Right? The maturity-wise.
The difference between privacy as compliance at the end versus privacy as strategy in building these new platforms and how you're going to do business. You have a whole different set of tools depending on where you come in.
Like they said in your session, it's a whole new way of learning.
Yes.
Right? You got to understand data flows. You got to understand the business strategy and technical strategy, so that you can advise on. Let me help you do the thing that you're
right. Like, I want to enable you. I need to know the facts. I'm not here to do a contract. No. A good lawyer, it's not about saying no. Yeah. It's like, how do we get there? There's a way to get there.
Yeah, I love that. And this, like, lawyers as a business partner, right? That's what I think you've always wanted. Thirdly, clean rooms. Talk about buzzword bingo. All right, so what are they supposed to do? Purpose limitation, data minimization, yeah, of course. I think we finally got to this point where people understand what clean rooms are and what they're not. And one of the quotes I really loved in that session was when one of the panelists said, the obligation to make sure that data is consented and permissioned is on the brand. Don't assume that it magically gets fixed in a clean room.
No, there's not a magic eraser that makes it all okay. They offer tools, they offer privacy enhancing technologies, they offer different ways to do data collaborations or analytics, but it's tools.
Mm-hmm.
It's tools, and they can happen anywhere with any kind of data collaboration. So it matters what you are doing in the clean room, what data you're bringing in, and the rules associated with that data, and then what are the outputs of the clean room. You don't. There's not a shortcut to get around looking at the data flows.
Yeah. And the obligation is for you.
And the obligation is for you.
It's
Yeah,
like,
the
don't just-
participants, either side.
Yeah, I love that piece of it. Fourthly, talked about digital outflows and the complexity of managing privacy. Geez, I mean, they showed a couple of flow charts and I thought they were awesome. That could have been a half-day session.
It absolutely could. Maybe I'll just flag one thing. IAB Tech Labs taxonomy on personal data and how do you flag that to the engineers? Because I thought that was a really good point. We're talking ad tech, we're talking privacy, but how do you build and make sure that you're talking with the right teams to support the ad tech privacy compliance overlay?
A lot of discussion around GPC on that point. And it seemed like businesses are taking this conservative approach on it, where I didn't hear anybody say, well, one person said it, I didn't hear anybody else say that, hey, we're just snapping to GPC in the 2 states that offer it. They're kind of saying the FTC, the way we interpret the FTC looking at this is consumer made a choice. And if they made that choice, we're going to apply that nationally as a brand that's looking to do right by the consumer. Also way less complicated.
Right, it's way less complicated. And they started talking about some of the complexities. Like, I know it's my customer, they're logged in. If they go on a trip to New York, I can't stop offering them the same privacy that I offered them when they were in California. Yeah. And so when you add in just real use cases that you can absolutely anticipate, the benefits of that start not looking so good compared to the risk that you're taking on if you take a very narrow interpretation of how you extend those rights.
So like people felt like they're finally getting the message that there's, on the UDAP laws, right, on the deceptive conduct, and all right, consumer made a choice. Then we think about it through that lens rather than how can I be super precise about this?
Right.
So lastly, you heard from Esther Chavez at the Texas AG's office. She was great. What did she say? Texans are feeling ornery about privacy, we asked them. I think she said they had something like 500 complaints.
Don't mess with Texas.
Like more than half of those were non-compliant. 12% were opt-outs.
Right.
So, I mean, going back to opt-outs, deletion, access, she thinks that's only going to increase.
And she said she's staffed up. Like her team has a lot of lawyers, and they now have a lot more tools that the Texas legislature gave them, and they're looking to enforce it. And so that was really, I think there was one line she said was like, get your documents ready. When you get these letters, you need to be able to show the homework, show how you've addressed the compliance. So
the movement has begun among state AGs. All right, whether federal law is going to happen, she said we're going to focus on interoperability with other state laws, other state AGs. People love that.
Right.
And I love this line. We want to maximize the utility of privacy rights for Texans.
That was straight up from the legislature intent. The other thing that I thought she said was really practical and very helpful is we hear so much angst about vendor diligence and assessments. And she reminded, like, look at the data security settlements, because there's tons of the breach settlements. And it used to be like, just hire a third-party auditor. It was very general. But now, when you look at those settlements, they're very prescriptive of, don't just do audits, don't just do diligence. What are you doing the assessment on? What about that was in the onboarding. What about during the period of engagement? Are you doing any monitoring? What about if you made the risk assessment that we don't need to put controls on that vendor? Did you evaluate consumer harm in the context of that? So really being able to talk through the process, the foreseeable harm, how did you address it with whatever the practices that a vendor may have caused some damage?
Thanks for reminding me of that, actually. That was great, because it reminded me of something you've been talking about for ages, which is about, it's not just the contracts, it's the controls. And what she said, Michael asked her about diligence. She said, sure, when you onboard a vendor, you do your assessments, make sure they're good, make sure the contract's right. And then she said, make sure the vendors are doing what they're supposed to be doing. And that came up in an earlier session, especially when there's an imbalance between a company as a data controller and a vendor as a processor. If that controller is much bigger in revenue, there's an expectation that they kind of know what their vendors are doing. So then she said, if you haven't done it, then get ready to tell me why.
Get ready to tell me why. And what about if you did the assessment, or it became known that you have a vendor that is not doing anything that they promised in the contracts, or where they started, that she's looking to see what did you do in response to that? And so you didn't ratify it. So she gave us a lot to think about.
Which is great. Well, thanks, Alysa. This was great. It was awesome. It was good to kind of see you on stage today as well.
Thank you.
Thank you.